Hi, everyone, and welcome back to another episode of our firm's podcast, Decoding with Finsec. And the idea behind this podcast has always been to find the time to sit down and talk about issues in the securities law space and the financial sector. I'm Rashmi, and I have with me Anil here today. And today we'll be discussing a case that has grabbed the attention of many lately, the Gensol Engineering case and the Jaggi brothers. So, Anil, I'm sure you're familiar with the case, but for the benefit of our viewers, I'd just like to set things into context. On April 15th, SEBI passed certain directions against the founders of Gensol Engineering. The SEBI has also debarred them from the markets and removed them from acting as directors on this entity's board. Now, for the uninitiated, Gensol Engineering is a sister concern of the well-known cab hailing service. When the service was launched in 2019, which is also when Gensol Engineering IPO'd on the SME board, it was hailed as the only all-electric EV cab hailing service and has also been very popular with users in the past few years. Um, so what happened in this case is now what SEBI has come out, SEBI investigated this matter, and apparently Gensol Engineering had taken loans from certain public sector entities, including Power Finance Corporation and another entity, to the tune of roughly, I think, 650 crores. This loan was taken to buy 6,400 electric vehicles. Now, out of this 650 crores, some 150 to 200 crores, SEBI has found was siphoned off by the two promoters, the two Jaggi brothers, for their personal expenses. One of which also includes purchasing a duplex in a luxurious
DLF Camellia.
DLF Camellia in Delhi, and several other use cases. Um, Now, it's very interesting the directions that SEBI has passed in this case. SEBI has not only debarred them from accessing the markets indefinitely, also barred them from acting as directors on this entity. SEBI has also ordered a forensic audit in this case. But I feel like what has been lost in translation in the middle of all of this are the shareholder interests. The share prices of this entity have taken, a big hit in the markets. There's obviously significant funds that have been siphoned off. Uh, Now, given this whole scenario, there are no directions that to me seem to be aimed towards protecting the shareholders' interests. If we look at the case in the aftermath of this order, four independent directors out of the five have left. Currently, they only have, if I recollect correctly, two directors active on the board. A number of senior management have resigned. Uh, there are other enforcement agencies that are also picking up this matter. In the morning, I read about how MCA is possibly initiating a probe. The enforcement department may look at money laundering allegations. The lenders are also will also be enforcing and recovering their loans from this entity. So a lot of action is being initiated against Gensol. It's in the middle of a lot of drama, but very little attention is being paid to the shareholders, right? Shareholders, the share price is what, around 150 this
110 from 1000.
yes, so that's a drop of 87% from the highest.
90%.
So what are your thoughts on these kind of directions? Do you think SEBI could have acted differently in this case?
I think first we should look at the perspective. What at its peak, Gensol was market cap of Gensol was 4,000 crores, roughly around that. Now it's 400 crore. So 3,600 crore has been wiped out from the market. Out of the 3,600 crore, assuming 50% is by the retail investors. 1,800 crores of retail investors have lost money. 1,800 crores. And who else has lost money? The lenders, 400 crores. Out of the 250 crores, they're saying siphoned over for 150 crores. So for a loan of 200 crores, which was siphoned off by the Jaggi brothers, allegedly siphoned off by the Jaggi brothers, what has happened is that market has lost more than 1,000 and retail investors have lost thousands of crores. So the impact to the retail investors, since it's dispersed, is never felt by the market regulators. But what is being felt is the lenders are going after 200 crores. Where did the money go? Let's take out the money. So the business is at a halt.
Yeah.
Lenders are coming to raise the money back. Uh, the main two guys you've picked out of the company, the Jaggi brothers. So, is there any chance of recovery of the company? is there any chance that, of course, there was a business. There's nobody is questioning that there was no business in that company. The question was whether these promoters were siphoning off some part of the fund that was meant for the company for their own personal whims and fancies. Now, what should, as a SEBI, as a market regulator, do at a stage when it finds out there is some mistake, some siphoning of funds? Is it the job of the SEBI just to prove to people at large we are taking action by just asking these two individuals not to come to office from tomorrow and say that you cannot access securities market, or appointing a forensic auditor? That's what they have done essentially in terms of the order, interim order. Now, the repercussion is that tomorrow from the cab hailing services is shut. There's practically nobody had the ED, SFIO, all kinds of inquiries happening, MCA, but the core management is not part of people who have to answer. They are not even there and can't even answer. And there is no rescue plan. There's nobody who can come and rescue the company. The people who have lost are only the lenders and the shareholders. Lenders to, they are big PFC, IRD, a huge loan. They have enough provisions to cover this loan. What about the retail investors? There were 100,000 retail investors in that company, and 100,000 retail investors have lost money. SEBI talks about a Feno trading, people have lost so much money and all. Here, when you had an opportunity, when you knew that tomorrow, if I pass an order, these two people will not come to office from tomorrow, there's no way that company can recover without that. SEBI could have found a situation wherein they could have trusted the independent directors, get them, or some committee, have some. If you see past cases, fraud is not the first time fraud has happened. Fraud has happened of siphoning of funds, where the fraud is in the nature of siphoning of funds from the listed company. What has happened in the past, if you say USL, Vijay Mallya case, where United Spirits was a cash cow, he took money from United Spirits and passed it on to Kingfisher Airlines for servicing their loan. SEBI found siphoning of funds. Then was the case of Religare and Fortis, wherein the Singh brothers, Balvinder and Shivan, they siphoned of funds. Both these companies revived. Kingfisher, of course, didn't, but USL is still in existence. The point is that in those cases, there were existing management, there was an existing business which could have survived. Here also, SEBI could have taken steps. They could have taken independent directors of confidence, formed a committee. Even in Satyam case, where MCA intervened and appointed a liquidator kind of a administrative company. Even ILFS case also, they formed a committee led by Uday Kotak, and they asked the committee to continue under his leadership and basically sacked the existing leadership. In this case, SEBI did not do any of these. They left the company at the lurch, at the mercy of nobody. And the investors have nowhere to go, nowhere to complain. No, and the company also, how would it survive? Who will decide, make the decisions? The two big stakeholders who holds percentage in the company. Right now, I think they hold currently 30%, if I'm not wrong.
35.
35% in the company. And I think that also will be lower because most of the shares are pledged by IRD and PFC. If the loan does not come, they'll sell the shares, and that also don't know how much value they will get. So anyway, they will also be back to zero. So from the point of view, there's nobody, retail shareholders cannot give. There's no institutional investor to speak of. So who's gonna take care of the company? The company is just going down the dogs, and that is where SEBI could have protected the interest of the investors who have invested in that company by taking appropriate actions towards ensuring that the company operational activities are taken care of, towards ensuring a smooth transition to new management. The company is in operation. The promoters were fraud, but the company is a genuine business concern. People have siphoned off money from there. That business could have been protected, but SEBI chose to take a just limelight of the show to say that I have taken action. But little protection has been given to the retail shareholder who lost thousands of crores.
I agree. I agree. In fact, I think a lot of the directions seem to be taken, without a lot of thought being given to the entire situation holistically. Ironically, in the order itself, SEBI has mentioned that this is an absolute failure of internal controls and corporate governance standards. It's even gone to the extent of calling the entity, the promoters, piggy bank. And parallelly, 2 days later, the chairperson in his speech also mentioned their SEBI's renewed focus on corporate governance and protecting shareholder interests and minority shareholders. So it doesn't seem to add up in my head. Even if we look at the timeline of the company, when it IPO'd on the SME board in 2019, the promoters held 96% of the shares then. It migrated to the main board in 2023. The shareholding percentage dropped to 70% after listing. and right now as we speak it's about 30 to 35%. In this uh, in this course, the course of the last few years, the share prices have taken a hit. It after it peaked at around 1200, it's come down 88%, and it seems like the promoters have offloaded a number of their shares, and this issue doesn't seem to be a part of the order. It's not being investigated, so to speak. The data is there, but it's not being thought of in that direction. So what do you think? Do you think similarly? And in what can be done in this case?
I think one important thing we need to understand here, what has SEBI done? SEBI has just asked these guys not to come from to office tomorrow in forensic audit.
Yes.
That's just a post-mortem of what has happened to a forensic audit. Two of the you guys don't come to office on tomorrow. That's the effective order. Tomorrow, there's not even a freeze on their assets. Tomorrow, this fellow says that DLF Camellia House, SEBI has no recourse. What is the allegation? Allegation is that you have taken away money from the company and for your personal piggy bank expenses. But what is your response as a regulator? Your regulator is saying that you do not come from tomorrow to office. That way, tomorrow they can sell the assets, nothing, no freeze on the assets. Secondly, from the point of investors, I have a huge issue when you said SME at the time of SME listing at 96%. These companies were done, not had a proper IPO in the main board. These were SME, one of the SME companies. We had seen past piece of SME. If you see past year also, SEBI had to make extensive rules as to how which SME companies can now access the
The
securities
higher
market
diligence
by higher
standards.
diligence standards. So point being that SME companies come without the required diligence. If you do a main board listing, you have to get 75% of QIB as part of your offer size has to subscribe. Then only the IPO goes for a successful IPO.
Mhm.
Even the promoter should be minimum 75%. Then only you go for an IPO. So these checks and balances are put in place so that an investment banker, merchant banker goes through the files. I, as a cap markets lawyer, some 18, 20 years back, when I have visited plants for before doing the IPOs, going and checked whether their due diligence is done. These SME IPOs don't go through the process. They go and get listed automatically in SME and then get migrated to main board without any institutional diligence, institutional shareholding, putting their own skin in the game, and they come and they are. If you heard stories about how the influencers market worked, and I have read stories as to how Gensol was promoted by influencers to the peak that it came from 100 rupees, it became 1,000 and back to 100. And that kind of stock market, and 100,000 retail investors cannot come. If you see top big large cap stocks, you will not find 100,000 investors, and then it's a huge number. I'm
Absolutely.
comparing as to what is large. I would not know the numbers, but it's a lot of numbers for a company with a market size of 4,000, market cap of 4,000 crores. It's not even large. At its peak right now, it's 400 crores, not even that. So from that point of view, I think what has happened is another test case wherein it has been seen that SME direct migration from SME to main board is risky. The main board, more people trade on main board. Once a company is listed on main board, there's an assurance on the investors who've been investing in securities market that they have come through a process of IPO, come through a process of due diligence by a merchant banker, come through a process of review of DRHP, RHP prospectus documents by the board at large. And also 75% of the issue size has been subscribed by QIBs, which are institutional investors who do their due diligence before investing. So that kind of insulates the retail from this kind of frauds. This company was IPO in 2019, 15 it's bust. In 3 years, 2 years main board listing is bust. And that is something very, very rarely seen. In my history of 15, 17, I've not seen a company going boom to bust in 5 years, which a listed company. And from that point of view, it is all the more important for SEBI to look into this entire process of SME listing, SME to main board listing, over participation of retail in stocks, pumped up stocks through influencers. These are steps SEBI has to take. SEBI cannot just take remedial steps. Okay, fraud has happened. Now I'll take one pass and order and get out of it. That I have done my job. And it is. See, if you see RBI, I see every day I watch IPL. They show RBI what you can do, what you cannot do.
Advisories and
Advisory. They put
cautionaries.
Amitabh Bachchan comes. Whole big thing happens. Even for if you see those phone calls now, if you make phone calls in Mumbai, you will get one description that please don't fall for frauds, cyber
Yes.
frauds and all. SEBI has not spent one money. Recently, they opened their own Twitter account. I think as good as late as last month,
Yeah.
and So there is no social media presence, there is no media presence. If somebody is circulating misinformation, at least there should be one person circulating the right information. At least some kind of investor education has to be pushed by SEBI. It cannot be the left at the mercy of the investor, and SEBI will only act as a policeman.
Correct.
So I think it's a mix of lot of things, but in a case like this, Gensol, which proves that how a stock comes from 100 to 1,000, and how people, which without going through the process of due diligence through an IPO process and attracting 1 lakh investors through this influencers, etc., and then going bust. And SEBI has entire process has only come out after the CRA. We'll come to the fiduciary's role as to how that's why I'm saying even for the fiduciaries, when you go for an IPO, there are fiduciaries, auditors, bankers, lawyers, everyone gets due date certificate, and then a main board listing. It's not an easy job for doing main board listing. But these SME companies bypass this route and they go through it, and that's when the retail are exposed.
Absolutely, those concerns are very, very real. Since you brought up fiduciaries, I believe this case really kicked off on SEBI's end because the CRAs in this case downgraded,
Credit rating agencies for the
yes, the
reverse. Yeah.
credit rating agencies, they downgraded the debt issued by these two public sector entities to Gensol to D. Um, and that is what I believe really kicked off this entire thing. And what's even more egregious in this case was that the promoters issued forged letters uh, by the lenders to these credit rating agencies to state that no, we're not defaulting on our obligations, we're consistent with our repayments. They also applied for withdrawal of their credit rating, saying our lenders have no issues, please go ahead and withdraw credit ratings. So that's the level of misconduct that's taken place in this case. But the way I see it, even if directions have been passed, they don't seem to be entirely remedial because shareholder interest, which is also a very core mandate of SEBI, is not being protected in this case. The board is simply left headless looking for solutions and actions coming from all case. So it can't simply be that you pass a direction and then you let the shareholders be at the mercy of the board, which doesn't seem to be functioning very well in this case. um, I also see, I've been reading about this case lately, and in the past week there are a lot of narratives that have emerged from parties involved in this case. The lenders have their own explanations, the directors have their own explanations, and it seems to be, and nobody really wants to take accountability for what went down. Everybody wants to give an explanation for how they could not have found out about this siphoning off of funds, which, if a little bit of more diligence was done, could have been identified. So it seems to be a post facto reaction to avoid responsibility, to avoid accountability. And what's, I think, shareholder interests are being impacted. SEBI's also mentioned that this corporate governance lapse is very material to the company's functioning because it holds a lot of infrastructure contracts of the government and public sector entities, which depends on credibility of the entity. Our operations was also impacted. An EV entity that might have taken off wonderfully. I think they were starting operations in Mumbai March
March.
of this year, and that unfortunately could not take place. So it also harms the startup confidence. VCs are coming up and they want to talk about identifying these red flags early. So there's a lack of institutional accountability, I think, in this case. Um, but do you think an issue of this sort could have been identified by certain parties at an early stage instead of, at this stage where not a lot can be done? And what do you think?
I think, see, frauds will happen, frauds have happened, frauds continue to happen. So I think it is very easy to come back and say postmortem who's responsible. But I think, as I discussed before, also for the main board listing, so that fiduciaries' roles are very important. In a case which is now currently a listed company, who are the fiduciaries? Independent directors. They are the first rats to run out of the ship. They are all of them have resigned without any
One
reason.
is remaining.
One is remaining. Three have resigned. So resignation is not a solution. That is what if they were independent directors of some sector who should have said, I will take ownership, will ensure that the company is passed through this phase, and whatever we are not party to this, but we are directors of the company, fiduciary to the shareholders, make sure that the company goes through this crisis. Nobody has come from the company and made a statement that we understand the promoters have siphoned the money, but the company is still in this.
It seems that they've abandoned ship.
Yeah, the 60-70% are held by shareholders, retail shareholders. They are
Correct.
all, and whatever institutions they may own. But the point being, the company is not the promoter's company. It is their holding is 35, which may go down to zero because of the pledging of shares. The company is still in existence. It's not owned by the two brothers. Somehow, what Indian mentality is that the person who's behind the company is the company are same. So let them go down the roads.
Yeah.
It's not that. It's the people who are suffering as the shareholders who have to be somehow the effort should have been made for the company to revive, and those efforts could have been made by independent directors. The the CXOs below that company could have taken that. SEBI could have taken that. MCA could have stepped in, like they did it in Satyam case. They got their administrator in ILFS case. There are avenues so that how the company can be revived. Even that's why I'm saying fiduciaries roles are very important. Fiduciaries who are independent directors, then their auditors. I don't know how much auditors could have known about this or could have verified. I'm not an expert, so I won't comment on that. But then there are lenders, lenders who lend the company. If there was a factory apparently in the order which said that, and there were hardly four people they found in the factory, there's nothing
Yes.
much there.
And
So
an electricity bill of 1 lakh per
can
month.
you imagine? So the point being that is where I'm saying that there has to be some kind of checks and balances to, if SEBI could have found out this in 15 days investigation, I'm sure lenders and sector, because there's also PFC, IRDR, public sector institutions, and we are also this whole green energy boom, etc., and they're lending indiscriminately or without any diligence. That also gives confidence to retail investor. Retail investor, PFC is lending, IRDA lending. They get the confidence that they must be doing some diligence before investing in those stocks, or before giving them loans of such high amounts. So I think that's when, for retail, I think whole concept of SEBI being set up, SEBI as an organization which is set up by Parliament, Act of Parliament, is to protect the retail investor. That's the preamble.
Correct.
Development of securities markets, protection of investors' interest. So if SEBI cannot take interest for investors at the paramount to ensure these minority investors are protected and their investments are protected, just passing orders without looking into the solutions of it, finding the right, if at all fiduciaries are responsible, find them also, because this signaling theory is very important.
Yes.
Retail guys trade on signaling. What is the
Yes.
signal thing? Oh, PFC is fine. Oh, the company is doing well. This was just profit and loss, and then the influencers were influencing. That all create the narrative, and SEBI as a regulator has to find a balance as to how interest of investors are protected. While of course you should take legal action against the people who've done wrong, but that should not be at the cost of the investors. That's how I'll put it. That from the point of view of fiduciaries, also SEBI should go after them at least, or take them into confidence. They cannot just leave it at and say, okay, fine, everybody, only these two people in the entire universe is responsible for the what debacle happened. These two brothers, nobody else is responsible. Which I think is, I think that they are not looking into the depth of the issue rather than just striking on the surface.
Absolutely. But do you think an issue of this sort, where the loan which is taken is not utilized towards the end use that it was taken for, is this something that at a board level can be tracked, such that it is caught by an independent director? Is that something?
I think, see, independent directors, if you think are not culpable, if you think at least, did SEBI go and ask the independent directors, guys, do you know about this is happening? This is what I found. Have you taken them into confidence and saying that this is the problem? Can you step up and get the ball rolling in the company? Can you take over if you guys are controlled, or somebody else get somebody professional CEO? Can you hire somebody and take control and let these guys off? Otherwise, you blame that you are also part and parcel of the entire
Yeah.
thing.
Yes.
Point is that it has to be some kind of a solution oriented, not like I'll just shoot the person who is guilty. Rest, if their family, the entire dependent family, their workers die, I don't care much about. So that is where I'm saying that there has to be a balance. There is no perfect solution. I'm not saying that independent directors were guilty or not guilty. I'm not aware of the facts, whether they could have known or should have known. I'm not going to get into that, because these are very, very factual questions. Unless you are part of the table discussion, you would not know. But from a generic perspective, I think solutions are more important than penalties. I think penalties have a role to play.
At least at an interim
It's an
stage.
interim order, of course. So from that point of view, I think some emphasis SEBI has to give on this when they say 11B is, again, being technical legal lawyers. Section 11B is the power under which you have to do interim ex parte order. Interim ex parte orders can only be given on two grounds: preventive and remedial actions. You have taken preventive action that these guys do not fraud. Again, what are the remedial action have you taken? Have you tried to remedy the situation at all? Stock price is going down, the cab service is stopped, the business got this. price which has come from 100 to 10 will become zero. How does it make a difference? Will it make any
Especially
difference?
if the lenders start selling.
Will it make any difference, or will the company be survived or go for bankruptcy, be sold? What will be the end of the company? Is there something, some kind of ecosystem has to be created if the fraud has, SEBI itself has to create an SOP. I think high time they create an SOP that if they find something, somebody fraud, promoters are siphoning of funds, what should they do next to ensure that the company is protected? They cannot just interim expert or should. What was the reason? They could have just taken the IDs or see for whoever taken people in confidence before issuing the ex parte order, saying that this is what we have found. How do you want to react to it? How do you want to find a solution to it? That could have been done and then gone to the extent of issuing an order, at least stop their hands. You could have said that these guys could not do any financial transaction for
But
the
do you
company.
think the size of the company, the size of the diverted proceeds had anything to do with these, the directions that were taken? In other cases, we've seen frauds of significantly larger magnitudes. This is an SME company that never went through an official IPO, like you said. The siphoning is off to the tune of 200, 250 crores, which is a large sum of money. But considering the frauds that India has seen before, it's not a whole lot. So do you think that that had a role to play in the kind of
I don't know.
directions?
I think from a loss to the investor is much more. I think loss to a public sector, in the just in banks or financial institutions, not that high on the priority from as compared to what investors which have lost so much of money, and that can never come back. And then no matter what, its share price is not going to go for 1,000 rupees anytime soon. So I think we are looking at the problem in a wrong way as to what is the size of the fault. I think that what
Hmm.
is the size of the impact of the fault? Default
Hmm.
size of the impact of size and people who are impacted. That is way more important than if I were the shareholder dispute. I one shareholder's siphoned the money for one shareholder. Only one shareholder is at a loss. It's a private dispute here. It's a public. That is what SEBI is for. SEBI is to protect those 100,000 people, stock investors who have invested basis the confidence that SEBI is protecting the market, and that's why they invest. SEBI is being government is pays fees, SEBI intermediaries pay fees. Anything how SEBI rates existence of SEBI is based on protecting the 100,000 people.
Correct.
I don't see one step apart from saying that I have found out that Gensol is a fraud. That another step that SEBI has taken, which has helped company to basically navigate the situation and help the shareholders.
I agree. I agree. What I gather from our conversation is that maybe SEBI could have stepped up, in this case a lot more. Simply gone beyond preventing, but also trying to remedy the situation from the minority shareholders, from public shareholders' standpoint. There are definitely a lot of narratives that are evolving as we speak every day. I believe the lenders going to,
The 200 crores that the lenders have lost, they can just Camellia can be sold, 100 crores comes right away. So
yes,
it's not like a dispute of that kind cannot be solved.
yeah,
It's not too much of an issue which could not have been solved for a market cap of the company had reached to 4,000 crores. I think they could have found a solution to it. I think it was not such big an issue that a solution could not have been found. You could have found an executive CEO who could have run the company and taken it forward because it was not a systemically important correct company, right? Like a Satyam was a large tech. Even for ILFS was a huge enough company that they
hmm,
thought they had to intervene.
hmm.
But they thought these are only 100,000 investors, only 200 crores. Why should I care about them?
Yeah, which can't be a stance that the regulator can take.
Not for the 100,000 investors at least.
Yeah, yes, absolutely. The case is evolving as we speak. This is only at an interim stage. We can expect to see the report of the forensic auditors 6 months after it's appointed. So let's see how the case goes. Hopefully, some solution is developed over the course of time. Maybe
Who
this.
will take the solution? As in who in the company is there to decide we'll take this solution or that solution?
Hopefully, we can get some capable directors
Who
to
by who?
join.
Who? That's one point is who will decide? The board is not. There are two board members or three two board members. Four have resigned. Three have resigned. Independent directors.
4 out of 5.
Four out of five have resigned.
Yes.
Two of the directors, the brothers, are not part of
So
that.
two are remaining on the board.
Only two. One
Yes.
independent and one with quorum.
None.
They won't even fill the quorum in terms of articles.
Yeah.
So I don't see how this company can go forward
Yes.
unless MCA intervenes. SEBI should write to MCA that in interest of protection of investors, you please intervene, get somebody to administer the board and take the company forward. It's a valuable business. There are cars which are there
Hmm.
sitting and doing
Hmm.
nothing.
Hmm.
It's lost to the Indian economy also.
It also
People
has a
were
separate EPC business in itself.
how what about I'm saying that
Yeah.
from the point of view, it's not like a business is not there.
Hmm.
Business is there that some people have looted 200 crores out of that business. That's all.
Hmm.
A situation could have been salvaged. That 200 crore also could have been recovered.
Absolutely, absolutely. So let's see, it's a very interesting case from a corporate governance standpoint. The next 6-7 months will decide a lot on, how SEBI views SME companies sort of that go through these issues. So that will be it for our conversation today.
Can we discuss the issue of whole how they invested in their own company through the funds of the company? They also did their own trading in their own company through how they siphoned off funds to their own one of the group companies, and that group company used to trade in Gensol.
Hmm.
And so the point is, I'll just take that in front for the
Sure.
audience. As in, one of the issues in this case is also that the promoters, the Jaggi brothers, had taken off the funds from the company, and that used the channelized that fund to invest in their own company by preferential allotment also. And also they have used, they parked into another company which is to trade in the Gensol stocks and made profits there. So the allegation is that they not only de- defrauded the company by siphoning the funds, but also manipulated the price of the stock. They themselves bought the shares under the pref allotment. People thought that investors thought, oh my God, they're funding their own money, putting their own money again.
So they must believe in
They
the.
may be the company, but it was, they didn't know that money was company's money only routing back and they're
Yeah,
investing.
yes, yes.
Plus, they had people to trade in the stocks of the company when they knew about the company, what is happening, what is not.
Hmm.
Their shareholding going from 96 to 35, they would have sold the shares at 1,000 rupees or whatever. I do not know the data. The data has not been given in the order. But if their shareholding was 96, come down to currently 35, 60% of the shares they must have sold at current price is 100. They would have sold 500, 700, 1,000 rupees.
Hmm.
Who knows? That data is not there. So they of course have done some insider trading also. They knew that they were taking this fraudulent transaction, and the company do not have that much of money
Hmm.
as they claim to be. They are defaulting on loans,
Hmm.
etc. So from that point of view, it's not the issue that only of the fraudulent siphoning, but also manipulation of stock, insider trading, etc. Allegations of that is also there, and also they have been read in paper that how people were paid for, influencers were paid to pump up the
Promote,
stock.
endorse the stock. Yep.
So from that point of view, it's not an only a siphoning of fund issue. It's also manipulation of the market, manipulation of wrongful disclosure to the exchange, putting companies' money being used for investing in the by preferential allotment of your own company.
Hmm.
These are the grave allegations,
Hmm.
and because that is why I have a lot of problems with the issue that this when the promoters themselves trade in this company, when the stock 96 96 should not have been allowed, 96 to 35 you come, and there is nothing, no question asked as to why they stop, why they are selling the company when they are asking people to buy the stock and they are promoting the stock.
Hmm.
And of course they knew about the fact that the company we are is not doing so well, and that's why they sold at the top price. Is there, well, they will SEBI disgorge that money also, because they must have made some money in the profits
Yeah.
doing
Yes.
this insider trading as well.
Hmm.
I think there's a lot which do not meet the eye, which have not been yet been identified in the in this proceeding. So let's
Hmm.
see what happens. But I think
Yes.
these are great things. They're the very shocking things that I've seen, and I wonder as to how the regulator can actually uh, prevent these things. Of when actually they should have some kind of monitoring when the promoters are selling. You should have an eye on it. Ki how can you 90 to 35 in 1 or 2 years?
Hmm.
There has to be some kind of monitoring of that. So we cannot just sit idle and think if somebody is selling 60%, of course there's some fraud. There's no doubt. You're asking people to buy your company, you're saying good company,